here, and I objected. No, listen, let me talk. I objected to the bond conditions before, I'm objecting to them now under the.
Listen, your objection is duly noted. You have very, very highly competent counsel, so we'll just let your counsel speak on your behalf. And so he already did. He made a motion.
Well, I object to you speaking on behalf of that.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days, and then you can just sit there anyway for it. Stop interrupting. Mr. Madeira made a motion to set this for a personal bond.
Case number, thank you. Calling case number 22393437. This is Pasadena Investments LLC versus Dwayne Davis Jr. and all occupants at 2170 East Jefferson, Unit 1007.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548 on behalf of the plaintiff. Your Honor, Mr. Davis at this time owes $6,706, court cost of $157. This is a subsequent hearing.
All right, Mr. Davis or Ms. Davis? Okay,
yeah, I'm the beneficiary of Dwayne Davis right here. The beneficiary.
What is it?
Are you Dwayne? Excuse me. Are you Dwayne Davis Jr.?
I'm the beneficiary owner right here.
Do you reside at 2170 East Jefferson, Unit 1007?
Yes, the estate does assign there.
Do you reside in that property?
The beneficiary, yes.
Do you? Who the person I'm talking to? Is that the person who is in this property at 2170 East Jefferson? You're not answering my question.
I don't fully understand it. Say it again.
All right. Okay. At this point, I don't see anyone who resides at 2170 East Jefferson, Unit 1007. If you do reside there, please make the court aware of it.
Okay.
Your Honor, since the defendant has not identified himself as the defendant in this particular case.
I just did. I just told you I'm the beneficiary.
Your Honor,
of the name.
Your Honor, since the defendant has not identified himself as a person in this property, he's attempting to try to act like he's a sovereign. This property is owned and is an apartment building. We're asking for a default judgment at this time. If he decides to pay it, that's great. If not, we'll be moving forward after time expires.
Before we proceed with this matter, can I ask the director of the beneficiary? I'm talking to the plaintiff, sir. My legal person, I'm showing you right here, a corporation. Can you write me in 21 days and provide me evidence that you have legal?
Your Honor, none of that is required by law in this court. I'm asking for a default judgment this time. Quit wasting the court's time. If he wants to file the appropriate court paper or identify himself to the court as you've requested on numerous occasions, then we can proceed forward. At this time, playing these legal games is against. I
have a birth certificate right here.
The law. Two, we provide the court with a lease agreement. We provide the court with the ledger. We're asking for a default judgment.
The court is in receipt of a summons, a complaint, a demand for non-payment of rent, as well as a lease agreement.
The summons was never notarized.
Signed with Dwayne Davis Jr., as well as the proof of service. Mr. Davis, Dwayne Davis Jr., how much is your monthly rent?
I want to say $900.
When's the last time you paid rent?
Long time. Siri paid my back balance, but Pasadena never put it to my account. So I consider Pasadena either took the money or what. I don't know what they did with it, but Siri definitely paid it. It's on the record. It's on my the record with the Siri. You can find it in their profile. But they're supposed to pay my back balance.
I don't know. I can't find it in my profile. So you qualify. Sarah paid. How much did Sarah pay?
They paid up to like September, but they didn't pay they're supposed to pay July, August, September, but Pasadena never put that to my account.
Your Honor, if it wasn't applied, my client didn't receive it. That is not our burden. Okay. It's his burden. But
that's in documents though that they were supposed to pay. I have it in documents.
Your Honor, I'm not going to sit and argue all day, Your Honor. Bottom line is, the money is for his benefit. It is not for my client's benefit. Just like paying a mortgage payment. If I send a mortgage payment in, if it's not received, it's still on me. If you send a mortgage payment on my behalf and it's not received, it's still on the person who has the mortgage. He's the renter. It is his responsibility to have the monies paid, or to whoever's paying on his behalf, that we receive it. We have done everything we're supposed to do. The documentation speaks for itself. At this time, again, I'm requesting for either default judgment or judgment by hearing.
And then I'm talking to the plaintiff. Can you just write me and saying that you have authority as a public servant to me?
Your Honor, I am not writing.
Excuse me,
I'm not
Mr. Davis. This is a landlord-tenant court. This is summary proceedings. This is the second hearing, and you're afforded legal counsel. Legal counsel was available. They said that they could not assist you at this matter. Are you even identifying yourself as Dwayne Davis Jr.?
No, I'm the beneficiary of that name.
So are you not Dwayne Davis Jr.?
No, I am not. I am not.
Okay. We are entering, the court has not received the call or answer from Dwayne Davis Jr. Does anyone on this Zoom reside at 2170 East Jefferson, number 1007? Is anyone present who lives in that property on this Zoom?
Your Honor, again, no one's responded, asking for my default judgment. We can submit it to the court before the end of the day, along with a full ledger.
Default judgment granted.
Thank you, Judge.
Please submit the paperwork. Call it, you're free to leave. Well, nobody identified themselves, so calling the next case.
Good afternoon, Your Honor. Don Stoll on behalf of the people, PA 7439.
Nicholas Darren on behalf of the defendant, Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could unmute yourself, state your name for the record.
Very good. Okay, I got it.
You got it.
All right, you hear me?
Yep.
All right. So this is People versus Martin.
Yes, Your Honor. I have spoken with the complaining witness at the time. He would like to proceed with this case, and the people would ask to set it for a settlement conference before we go forward with the trial to see if there's a resolution.
All right. And Mr. Darren?
I mean, Your Honor, I guess we're gonna proceed that way. I was hoping, I'll renew my motion from the last time. Mr. Martin's been incarcerated, I think it's like 62, 63 days now. Court rule is pretty clear. If he's in over 28 days, he should be released on a personal bond. Mr. Martin's just been sitting in jail on this matter. I mean, I guess from practical, I would imagine the court's going to give him credit for time served, regardless of what the resolution is on this matter. Considering he's done over, at this point, he's done over 2/3 of what his original sentence would be. We're not going to accept an offer on this, and I guess we'll just set it for a settlement conference then, if that's what sister counsel wants.
And Your Honor, it's I know this case has been going on for a while.
Personal bonds.
That's correct. The issue here is that him and the victim are brothers. They live at their family.
First, I want to deal with the whole bond thing. His bond is $2,500 personal.
So I think the issue with that is I was having a cover last week, but per the notes, if you recall, you ordered him not to return back to the property because there's a no contact order in place. 2 weeks ago, when Mr. Brother Counsel appeared for the first time on this case, I believe I agree. And that's when the bond was changed, but Mr. Martin, Judge Kirsten. Yes.
So Your Honor, Judge Kirsten changed his bond, and then after some further statements were made, he changed his ruling to leave Mr. Martin in jail.
And that's because Mr. Martin made comments about returning back to the location, the home where the victim lives. And to my knowledge, per my conversation with Mr. Martin, the victim today, he indicated he'll be leaving the hospital, returning to that house tomorrow.
Right. All right. So I'm going to
I mean, I have no objection.
Mr. Martin, now listen, you understand, I wasn't here, but Judge Kirsten, your original bond was $2,500 personal. Then he said it at $2,000 cash, because of the alleged violation that says it says need to set a hearing on violation ASAP. I don't know if there was I don't see anything whether there's an alleged violation of the bond condition. Is that right?
Not an alleged
Or the
violation,
alleged was
he made
just-
comments
he made a comment about
that
it.
he'll return back to
So
the house.
this is why something. All right, so you understand you can't go to that house while you're on that. That's while the bond's in place. You understand that? Stay somewhere else. You understand that?
No, I do not understand, and I gotta stand up. First, I have nowhere else to go. Okay, so that's why I must return back there, and I objected. No, listen, let me talk. I objected to the bond conditions before, I'm objecting to them now under due.
Listen, your objection is duly noted. You have very, very highly competent counsel. So, let's let your counsel, speak on your behalf. And so he already did. He made a motion.
Well, I object to you speaking on behalf of them.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days and then you can just sit there anyway for it. Stop interrupting. Your Mr. Madera made a motion to set this for a personal bond. I'm going to set your bond at $2,500 personal. No contact with the victim or the victim's home location. If you show up at that location and violate my bond, you could be held in contempt of court. Just want to make sure you understand that. I'm just telling you that right now. So I'm setting your bond at $2,500. I'm granting the defendant attorney's motion. And the bond's $2,500 personal, no contact with the victim, and no leaving the state of Michigan without the consent of the court.
I got something to say.
And you have a right to remain silent, and anything you say can be used against you, and you already have an attorney who's talking on your behalf, and I've already granted his motion and changed the bond to personal, so.
Hey, well, I have something to say in response to that.
See everybody at trial.
I have something to say in response.
We'll see everybody at trial.
Your Honor,
Mr. Darren, do you have anything else further?
Your Honor, are we going to set it for a settlement conference, or are we just going to set it straight for a trial?
Sure, I'll set it for a settlement conference, and then a week later it'll be the trial.
All right. Your Honor, I understand the court's position. I mean, if Mr. Martin wishes to make a statement on his behalf, I can only advise him that I wouldn't. But if Mr. Martin wishes to make a statement and the court wishes to hear it, I don't have any. I mean, I'm not going to. I'm advising him not to say anything. But Mr. Martin, if the judge wants to hear it, if he's allowing it, then I will. I'll step aside and let you stay.
Mr. Martin, I've already granted your attorney's motion to set the bond at $2,500 personal. So if you have some other statement you want to make, I'm just going to reassure you again that you have the right to remain silent. Plus, your attorney's already said that, hey, you know what, it's probably a good idea to just do so. But go ahead.
But yes, like I said, I'm going to exercise my First Amendment right to speak, and I have a lot to say, so I ask that you don't cut me off or I'm done talking now. I object to the bond conditions and stuff. I can't be in my house. It violates my due process rights. I have nowhere else to go, and he's not the true victim. He's lying, saying he's a victim, but I told the cops when they arrested me that I was the victim. And so we have an equal protection clause violation.
All of that'll be the subject of the trial itself. So we'll hear everything you have to say about that at trial. Your objections duly noted. But that doesn't change my bond. Mr. Darren, you'll be receiving the date and time for the settlement conference.
Thank you very much, Your Honor. You have a great day.
You too.